Welcome to this deep dive. You have provided us with a truly fascinating source. A landmark Supreme Court patent case that, more than any other, really defines that thin, tricky line between legitimate competition and intellectual property piracy.
It really does.
We are diving straight into the heart of patent law and one of its most essential and often highly controversial concepts, the doctrine of equivalence.
This is a cornerstone decision, for sure. It's one that every IP lawyer, every inventor, and frankly, any major manufacturer still has to deal with today. The case is Graver Tank and MFG company Linde Air Products Co.
Graver Tank.
Yeah, and it's a crucial study in this permanent tension between the goal of protecting an inventor's true genius, the real substance of their discovery, and respecting the literal black and white language of the legal claim they wrote down.
So it's the spirit of the law versus the letter of the law.
Exactly. The accused company swapped out one chemical for another, so it wasn't a literal copy anymore. But the whole function of the invention, it stayed exactly the same.
And that's the core conflict, right? Functional identity versus a formal, literal difference. We're going to unpack why a simple chemical substitution, manganese for magnesium, ended up before the highest court in the land, not just once, but twice, to set this foundational rule.
It's an incredible story.
So our mission today is to give you a really comprehensive understanding of this complex legal landscape. We'll systematically cover the case identity, the intricate technical facts that sparked the whole dispute, the central legal questions the court had to wrestle with.
The arguments from both sides, which were powerful.
Absolutely. Then the Supreme Court's definitive holding, and most importantly, the profound practical legacy this 1950 decision left behind for modern technology and, litigation strategy today.
Let's get into it.
So we'll start with the formal identity of this decision. If you ever need to look up the one ruling that truly defines the doctrine of equivalence, well, this is it. Let's get the nuts and bolts down first. The case identity details.
Okay, so the full name of the proceeding is Graver Tank and Mfg Co. Inc. Et Linde Air Products Co. And, it's important to note this case wasn't decided on its first visit to the Supreme Court.
Right.
This specific ruling came on rehearing, which is why its case number is just number 2.
Okay, and the specifics. Which court? The timeline.
This is the Supreme Court of the United States. The final decision was handed down on May 29, 1950. The arguments themselves took place just a couple of months before, on March 30th, 1950. And for anyone looking it up, the formal citation is 339 U.S. 605.
Now, the majority opinion is what really defines the modern framework for this doctrine. Who wrote that critical opinion?
That would be Mr. Justice Jackson, delivering the opinion of the court. It's also worth noting the judicial lineup. Mr. Justice Minton took no part in the case, which can happen, if a justice joins the court late in the game.
And there was a dissent, a pretty powerful one.
Oh, absolutely. We will dive deep into that. The dissent was led by Mr. Justice Black, and he was joined by Mr. Justice Douglas. Douglas even wrote his own separate dissent as well. They did not hold back.
Okay, and the parties themselves, who was on each side?
So you had the petitioners, who are the accused infringers. That was Graver Tank and MFG Company, Inc., and a few other companies. On the other side was the respondent, the patent owner, which was Linde Air Products Co.
And this was a high-stakes case. The lawyers must have been top tier.
They were. For the petitioners, you had Thomas V. Koika, John F. Oberlin, and Charles L. Byron, and arguing for the respondent, Linde, were John T. Cahill and Richard R. Wolff. This was, really a battle of the heavyweights in the 1950s patent bar.
Okay, so let's move into the key facts and what is a pretty complex procedural timeline. This wasn't a clean, simple lawsuit. This was a grueling, multi-year legal war that, as you said, took 2 trips to the Supreme Court. What was the origin of the whole dispute?
The dispute was all about an invention by Linde Air Products. Specifically, it was a process for electric welding, what's known as submerged arc welding, and the chemical compositions or fluxes that are used in that process. Linde owned the Jones patent, number 2,043,960.
And they sued Graver for infringement.
They sued several companies, including Lincoln and the Graver companies, accusing them of infringing on that patent.
So what happened at the very first level, the district court trial?
The trial court came back with a mixed verdict. It found that 4 of Linde's specific flux claims were valid and that Graver had infringed those 4. But, and this is a big but, it held that some of the other flux claims and all of the process claims were invalid.
So a partial victory for Linde. It kept their protection pretty narrow.
Exactly. Very narrow. But then it went to the Court of Appeals, and they changed the scope of it significantly. Well, the Court of Appeals agreed with the trial court. on the validity and infringement of those first 4 flux claims. But then they reversed the trial court on all the other contested claims. They said the process claims and the remaining flux claims were also valid.
Wow. So that decision massively broadened the scope of Linde's patent protection. That would have set off some alarm bells.
It did. And that expansion is what triggered the very first Supreme Court review back in 1949.
Because the stakes were suddenly so much higher.
Exactly. With that split between the lower courts, Supreme Court attention was pretty much guaranteed. In that first review, the court took the case and ended up reversing the judgment of the Court of Appeals. And critically, they reinstated the narrow district court decree.
So after all that, they were right back where they started. The only valid part of Linde's patent were those original 4 specific flux claims.
Precisely. But the story doesn't end there. Graver Tank, the accused infringer, was still on the hook for infringing those 4 claims, but not literally. It was based on the doctrine of equivalence. So why the rehearing?
Yeah. What was left to decide?
The first Supreme Court decision left a lot of confusion about how to apply the doctrine of equivalence, especially, its procedural place in the legal framework. So a rehearing was granted, but it was strictly limited to 2 very precise points.
What were those 2 points?
First, they focused only on the question of infringement of those 4, and only those 4 valid flux claims. And second, and this is probably the most important part for legal precedent, they focused on whether the doctrine of equivalence was a finding of fact.
So it was a focused effort to clarify the legal mechanism.
That's it. And crucially, the validity of the claims was not up for debate again. The court was only looking at whether Graver's product crossed the line into infringement based on equivalence, and just as importantly, how a court is supposed to figure that out.
Okay, so this procedural clarity then forced the Supreme Court to face a really fundamental question of chemistry and function. Let's get into the specifics. What was the chemistry behind Linde's patented composition?
So the patented composition was sold as Union Melt Grade 20. The claim was very explicit. It was for a welding flux that was a combination of alkaline earth metal silicate and calcium fluoride.
Alkaline earth metal silicate.
Right. And the actual flux they produced used silicates of calcium and magnesium. Both of those are, chemically speaking, alkaline earth metals. So it fit the claim perfectly.
Okay, we should probably pause here for a second. For those of us who aren't industrial chemists, what exactly is a welding flux, and what is this alkaline earth metal silicate actually doing in this whole process?
That's vital context here. So submerged arc welding is an industrial process where the electric arc is hidden or submerged under a blanket of this granular material, the flux. The flux has 2 main jobs when it gets hit with the incredible heat of that arc, which can be over 3,000 degrees Fahrenheit.
And what are those 2 jobs?
First, it melts and creates a protective gas shield around the molten weld metal, which stops it from getting contaminated by oxygen and nitrogen in the air. Second, and this is the crucial part for this case, it reacts with impurities in the steel and forms a molten slag that floats on top of the weld.
Ah, so the alkaline earth metal silicate, the calcium magnesium silicates, are what form that protective chemical slag.
Exactly. Alkaline earth metals are known for being very reactive and stable at high temperatures, which makes them excellent for forming slag and refining metal.
Okay, got it. Now let's look at the accused product, Graver Tank's Lincoln Weld 660. What was the change they made?
The accused composition, Lincoln Weld 660, was, for all practical purposes, the functional twin of Union Melt, except for one critical substitution in that silicate component. It used manganese silicate where the patent specified magnesium silicate.
And here is the fact that caused this entire decade-long legal battle. Is manganese an alkaline earth metal?
No, it is not. Chemically, manganese is a transition metal. The periodic table is very clear on that. The patent claim was literal, it was specific, it was unambiguous. And the accused composition did not meet that language.
So that means Linde couldn't prove literal infringement?
Not a chance. They had to rely entirely on this equitable doctrine.
But as you pointed out, the compositions were otherwise functionally identical.
They were. The evidence was indisputable. In operation, the 2 compositions were alike. They produced the same kind and quality of weld. They met the same industrial standards. This functional identity, despite the chemical difference, is why the doctrine of equivalence became the entire focus of the case.
Okay, that sets the stage perfectly for the legal questions. What were the central issues the court had to resolve during this limited rehearing?
There were really three core legal questions. First, just on a substance level. Did the substitution of manganese, a non-alkaline earth metal, for magnesium, which is an alkaline earth metal, constitute infringement under any legal theory, given there was no literal match?
And the second question went right to the heart of the doctrine itself.
It did. Specifically, could the doctrine of equivalence even be legally applied to a chemical composition where the accused product didn't meet the exact chemical language of the claim? I mean, Graver was arguing that chemical claims have to be read literally. Otherwise, you destroy the whole point of a patent giving public notice.
And the third question was procedural, but it sounds like it had massive implications for patent litigation from that point forward.
Absolutely massive. The third question was whether the determination of equivalence, this judgment call about an insubstantial change, is a matter of law for judges to interpret or a matter of fact.
And if it's a matter of fact,
Then it would be subject to the really strict and highly deferential, clearly erroneous standard of appellate review under Rule 52A. That procedural designation, as we'll see, turned the whole world of patent litigation on its head.
okay, let's unpack this core concept then. Why, fundamentally, does the legal system even need a doctrine that goes beyond the literal defined text of a patent claim? I mean, isn't the whole point of a patent to tell the public exactly what you claim?
That is the core statutory argument, and it's the one the dissent used so powerfully. But the majority recognized a critical practical flaw in a system that's based purely on literal reading. They noted that relying only on the literal words would convert patent protection into a hollow and useless thing.
That phrase, hollow and useless thing, that really captures the need, doesn't it? What was the behavior they were trying to stop?
They were trying to stop the unscrupulous copyist from making unimportant and insubstantial changes and substitutions. Changes that, add nothing to the invention but would be just enough to take the copied product outside the literal claim, and so outside the reach of the law.
So the typical pirate isn't making an exact duplicate. They're introducing some tiny, meaningless variation just to cover their tracks.
Precisely. They know they're benefiting from the inventor's core discovery. If the law only punished exact copies, the inventor's time and money spent disclosing their work would be wasted. It would subordinate the substance of the invention to these tiny verbalistic differences.
The doctrine of equivalence, then, is about ensuring fair play.
Exactly. It arose almost a century before Graver Tank to address this practical reality.
So let's define the core principle.
Yeah.
What is the test that courts use to figure out if an accused product crosses that line?
The essence of the doctrine, which is rooted in equity, is that one may not practice a fraud on a patent. And the legal test, which is still the gold standard today, is called the function-way-result test.
A function-way result.
Right. It basically says that if two devices do the same work in substantially the same way and accomplish substantially the same result, they are the same, even though they differ in name, form, or shape.
That functional approach seems way more flexible than a strict chemical rating. Where did this idea of equivalence even come from?
It's an old concept. It goes all the way back to Wims v. Denmead in 1853. That case dealt with a mechanical component, a difference in the shape of a railroad car. But it's expanded since then. The Graver Tank decision was so crucial because it definitively confirmed that the doctrine applies not just to mechanical changes, but to complex chemical compositions, like these welding fluxes.
And this applies even if the invention isn't some huge world-changing breakthrough.
Absolutely. The court clarified that it protects not just pioneer inventions, but also secondary inventions, like Linde's improved flux, which might be a combination of old ingredients that just produce a new and useful result. It's broad enough to protect that kind of incremental innovation.
Now, here's where it gets really interesting for legal strategy. The court said this is a balancing tool. It can actually operate against the patent owner. How does that work?
And that is a critical check on the patentee's power. If a competitor's device falls within the literal words of a claim, but it's so far changed in principle that it performs the function in a substantially different way.
The doctrine can be used to defeat the infringement claim.
Exactly. The court cited an old case, Westinghouse v. Boyden Power Brake Co. The doctrine is not a one-way street. It's a tool for achieving, as they put it, wholesome realism in the law, to prevent unfairness for both sides. It makes sure the patent only protects the actual inventive principle, not every single literal component in a vacuum.
Okay, so with the doctrine defined, let's turn to the specific battle between Linde and Graver Tank. What was Linde's main argument to try and prove infringement?
Lynn's whole argument really hinged on this idea of functional identity. They argued that Graver Tank's substitution of manganese silicate for the alkaline earth metal silicate was a classic example of a colorable change.
Ooh, a colorable change.
Yeah, a transparent, insubstantial effort to copy the heart of the invention while dodging the technical legal language. Their point was simple. Since the substituted manganese silicate performed the identical function-forming slag, binding impurities, and achieved the identical result, a high-quality weld, it had to be an equivalent.
And Graver Tank, the defendant, was just holding firm on the literal language. What was their main counterargument?
Graver's defense was all about the statute and the Constitution, really. They argued that the patent claims clearly, explicitly specify alkaline earth metal silicate. Manganese is not that, period. Therefore, no literal infringement.
And they argued the court couldn't just expand the claim.
Right. They said you can't use an equitable doctrine like equivalence to stretch a claim beyond its plain language, especially since Congress requires inventors to distinctly claim their invention. Graver's position was simple. Linde drew its property line in the wrong place. What isn't specifically claimed is, by law, dedicated to the public.
So Graver was basically demanding that the law be predictable. They should be able to read the patent and know if their new product is safe to market.
Precisely that. They believe this kind of uncertainty undermines the whole competitive market. If the inventor wrote the claim too narrowly, well, that's their mistake in drafting. And the public shouldn't have to deal with the consequence of a court retroactively expanding the claim.
So, moving to the holding. What was the court's ultimate decision on the rehearing?
The Supreme Court affirmed the judgment of the trial court. They found that the 4 valid flux claims were infringed under the doctrine of equivalence. They conclusively held that the substitution of manganese silicate was, quote, so insubstantial that the patent was infringed.
This brings us back to that crucial procedural point. A huge reason the Supreme Court upheld this finding was because they defined equivalence as a finding of fact. Why is that so critical to the legacy of Graver Tank?
This is maybe the most seismic procedural shift from this case. The court explicitly designated a finding of equivalence as a determination of fact. That's essential because it dictates the standard of review on appeal.
And that standard is?
Under Rule 52A of the Federal Rules of Civil Procedure, findings of fact made by a trial judge should not be disturbed unless clearly erroneous. That is a very, very high bar to clear.
So this procedural move instantly elevated the power of the trial court judge in patent cases.
Massively. Before Graver Tank, it was kind of uncertain. After this decision, if you're fighting a doctrine of equivalence case, your whole strategy has to shift. You can't just hope an appellate court will reinterpret the law in your favor. It made these cases intensely fact-driven, much more expensive, and it put a huge premium on the trial judge's first-hand look at the evidence.
It sounds like the Supreme Court was basically saying, look, we're appellate judges. We're not chemists or metallurgists. We have to defer to the judge who actually lived in the details of the science for weeks on end.
That is the core rationale. Justice Jackson stressed that this standard is uniquely appropriate for these kinds of technical cases. Patent disputes rely on, familiarity with specific scientific problems and principles not usually contained in the general storehouse of knowledge and experience.
The trial judge is just in a better position to make that call.
Way better. They sit through weeks of complex, often conflicting expert testimony. They see demonstrations. They're deemed the best and most accurate arbiter of that functional equivalence. The Supreme Court was deliberately stepping back from second-guessing that complex factual finding.
So the majority's reasoning for upholding the trial judge's finding seems really meticulous. They didn't just rubber stamp the conclusion. They provided a detailed framework for how equivalence must be assessed. What were the specific factors they said must be considered?
Right. They laid out a 4-part test, basically. This requires a really intensive look at, 1, the purpose for which the substituted ingredient is used in the patent, in this case, slag formation.
Okay.
2, the qualities the ingredient has when it's combined with all the other ingredients in the flux. 3, the function it's intended to perform in the whole process, so the welding itself. And 4, maybe the most critical part, whether a person reasonably skilled in the art, an industry chemist, would have known that these 2 ingredients were interchangeable.
This idea that equivalence is not the prisoner of a formula suggests they were looking for a common functional thread, not just, complete chemical identity. How did the evidence presented at trial actually support this finding that manganese and magnesium were interchangeable?
The record was overwhelming. They pointed to extensive expert testimony where chemists and metallurgists testified that manganese and magnesium, while technically in different chemical families, behave so similarly in many high-heat reactions that they serve the exact same purpose in these fluxes.
So structurally different on paper, but functionally identical when you blast them with the heat of an electrical arc.
That's it exactly. The trial judge heard testimony that in the specific context of creating this molten slag for submerged arc welding, the functional properties of manganese silicate were, for all practical purposes, interchangeable with the claimed silicates. One chemist even testified that, in the sense of the patent, manganese could be considered an alkaline earth metal.
Which shows that the technological application sometimes overrides the strict academic classification.
Right. And the court didn't just look at testimony, they required corroboration.
What else was there?
Well, the testimony was backed up by references to recognized textbooks on inorganic chemistry. These confirmed the known similarities. And, crucially, there was no evidence at all that Graver's Lincoln Weld flux was the result of some independent research or experiment. The trial court was justified in concluding that it was just imitation.
A deliberate attempt to copy the function without literally copying the text.
Yes. Now this brings us to the precedents and prior art the court used, which is a fascinating twist. Usually prior art is used to invalidate a patent. Here, they used it to strengthen the finding of infringement.
How did they do that? How do you use prior art to prove something is an infringement?
It was a brilliant move by the majority. They cited two patents that came before the Jones patent to establish that this substitution of manganese wasn't some mysterious or complex new discovery. It was technology that was well known in the industry for decades.
What were those two patents?
First, they cited the Miller patent, which explicitly taught the use of manganese silicate in welding fluxes. And second, the Armor patent, which similarly disclosed manganese in a welding composition.
Now hold on. If the Miller and Armor patents already disclosed using manganese silicate, why didn't that prior art invalidate Linde's patent in the first place?
That is the critical distinction. Linde's patent was deemed valid because their specific combination, those four claims that survived, created a new and unexpected result, even if some of the components were old. However, the existence of those patents proved one crucial thing, that the interchangeability of manganese silicate and alkaline earth metal silicates for slag formation was established knowledge for anyone skilled in the art.
So the court's argument was essentially, Graver didn't invent anything new by swapping in manganese. They just made a substitution that any industry chemist knew would work the same way.
Absolutely.
Yeah.
And that made the change, in their words, colorable only. It took away Graver's ability to claim they had made some independent innovation or surprising discovery. The substitution was easy, it was obvious, and it was functionally irrelevant to the core invention.
And finally, just to circle back to the trial court findings, the Supreme Court gave extraordinary deference to that trial judge. How did they justify that deference based on the judge's personal involvement?
They spent a lot of time on this.
Yeah.
The trial judge had presided over a massive 3-week trial. And during that time, he had gone above and beyond. He actually went to laboratories with lawyers and experts to observe actual demonstrations of welding using both the patented flux and the accused flux.
So it wasn't just book knowledge for him, it was field research conducted by the judge himself.
Exactly. He also viewed motion pictures of various welding operations and tests. This deep personal immersion in the technical facts is what justified that Rule 52A deference. The Supreme Court relied on the fact that the trial judge found the two fluxes were substantially identical in operation and in result.
So, given the evidence and the judge's deep dive, the Supreme Court just couldn't say he was clearly erroneous.
That's it. They concluded his findings were adequately supported by the record, and therefore the use of the doctrine of equivalence was completely justified.
But while the majority established this equitable need for the doctrine, Justice Black and Justice Douglas launched a blistering attack on that reasoning. They argued this judicial expansion just fundamentally undermined the entire statutory structure of American patent law.
Oh, yes. The dissent was powerful, led by Mr. Justice Black. His primary objection was that the decision amounted to the court, in his words, sterilizing acts of Congress that govern how an inventor must claim their invention.
And he starts by pointing out that the trial court itself admitted there was no literal infringement.
That's the anchor of his whole argument. The claim required a major proportion of alkaline earth metal silicate. Manganese is not that. Black argued that by using this judicial doctrine of equivalence to retroactively pull manganese into the claim, the majority was just overriding a direct, non-negotiable mandate from Congress.
And that mandate is RS Section 4888.
Yes, the statute that requires distinct claiming.
So what does that statute actually demand, and why was it so crucial to the dissent?
It requires an applicant to particularly point out and distinctly claim their invention. This is Congress saying, inventor, you have to draw clear, specific public boundaries around your intellectual property. Black's point was that the claim, and only the claim, measures the legal grant. Anything not specifically claimed is legally and irrevocably dedicated to the public.
This fear of expanding the claim beyond the written text is what led to Justice Black's famous, really colorful phrasing, right? The nose of wax analogy.
Yes, the nose of wax quote, which he took from an earlier case. He warned against treating a patent claim like a nose of wax which may be turned and twisted in any direction, just by referring to the specifications. He insisted the claim had to be the definitive boundary. If the public can't rely on the literal words of the claim, the entire system of public notice just collapses.
That's a powerful philosophical conflict. Equity for the inventor versus statutory certainty for the public.
It is. And Black also argued that if Linde genuinely made a mistake by excluding manganese, Congress already provided a specific regulated way to fix that error.
What was that mechanism?
He pointed to the reissue statute. This statute allows a patent to be reissued if it's inoperative because of an error or mistake.
And why did Black believe the reissue statute was the only proper way for them to fix this?
Because the reissue process has crucial administrative safeguards. It's handled by the Patent Office, which scrutinizes the change. And most importantly, it explicitly bars lawsuits for retroactive infringement based on the expanded claims. So if Linde had used the reissue statute to add manganese, Graver Tank would have been protected for its past actions, but would be on notice going forward.
So Black's point was that the majority was using the doctrine of equivalence to bypass all those congressional safeguards and grant the patent owner a retroactive monopoly expansion that Congress had explicitly regulated against.
Absolutely. He saw the court as just nullifying the reissue process and making claim expansion the rule, not the exception. And he believed that reversed decades of precedent meant to protect the public domain.
He also highlighted a pretty suspicious detail, didn't he, about the inventor's own actions regarding manganese.
He did. He noted that Linde's own inventors had actually experimented with manganese silicate during development, but they consciously excluded it from the final valid claims. They chose to rely only on the alkaline earth metals.
And Black argued this omission was intentional.
Yes. Why? Because including manganese might have made the entire patent invalid, due to the very prior art the majority relied on, like the Miller patent, which already taught the use of manganese. Black argued that if Linde intentionally chose to narrow their claim to get it through the Patent Office, the courts shouldn't be the ones to rescue them after the fact.
So what was the practical, chilling consequence that Black predicted for competitive industry if the majority's ruling stood?
He argued the decision injected crippling uncertainty into the market. A manufacturer can no longer just rely on the plain language of a patent claim to know if they're infringing. Instead, they have to be able to forecast how far a court relatively unversed in a particular technological field will expand the claim's language.
So you're always guessing.
You're always guessing based on often conflicting expert testimony, years after you've already launched your product. He believed this ambiguity just crushes competitive economy and innovation among competitors.
Okay, let's turn to Mr. Justice Douglas's separate dissent. He brought up a critical point about the patentability of the substituted element itself.
Douglas focused on the public domain. He agreed that specifications can be used to limit a claim but never to expand one. But the key point he raised was that manganese silicate had been explicitly covered by prior expired patents, like that Miller patent.
If it was covered by an expired patent, it was unequivocally in the public domain. Anyone could use it.
Exactly. And Douglas argued that by extending Linde's current, valid patent to cover manganese silicate under this doctrine, the court was creating a strange anomaly. A monopoly is obtained on an unpatented and unpatentable article. He said it should have been freely available to the public. He concluded that this just subverted the entire constitutional and statutory scheme for patents.
It's clear that the dissent saw the majority's decision as a really dangerous precedent, one that prioritized a specific patent owner over the structural integrity and public notice function of the whole patent system.
That's absolutely right. They saw it as judicial overreach, substituting the certainty of the statute for the subjective functional assessment of a single trial judge.
So after this incredible legal battle that all hinged on a single chemical substitution, What does this all mean for the world of innovation and manufacturing today? What is the lasting legal significance of the Graver Tank decision?
I mean, this decision is monumental. It did three essential things for U.S. patent law. First, it permanently affirmed and codified the vitality of the doctrine of equivalence. It established that patent protection is based on the substance of the invention over the literal form of the claim. It's a necessary, equitable safeguard against piracy that is now just indispensable.
And second, it totally revolutionized how patent litigation is conducted through that procedural designation we talked about.
Yes. It strongly cemented the rule that determining equivalence is a question of fact for the trial court, shielded by that clearly erroneous standard. This decision single-handedly elevated the importance of technical evidence and expert testimony. It means winning a doctrine of equivalence case requires overwhelming factual proof of functional identity, not just clever legal arguments about how to read a claim.
So if you fail to convince the trial judge on the facts, it is extremely difficult to win on appeal.
Almost impossible. And it formalized this tension in patent law. The need for strict notice from the claims, which was the dissent's position, versus the equitable need to prevent fraud on the patent grant, which is the majority's position. Graver Tank is the definitive judicial attempt to strike that balance.
Okay, finally, if we had to distill this massive, complex case down to the single most important key takeaway, what would it be?
The most crucial takeaway is the definitive establishment of that three-pronged function-way result test for equivalence. This is the practical rule that governs competition today. A competing product infringes if it performs substantially the same function in substantially the same way to obtain the same result, even if it avoids the literal wording of the claim.
So in these complex technological fields, it's that functional similarity that matters most.
It is. If that similarity is supported by evidence that the substitution was known and obvious to people skilled in the field, that's what determines the boundary of the intellectual property, overriding these minor formal differences. The invention is protected in its operational essence.
This deep dive really shows us that in the world of patents, the written word is powerful, but context, technical function, and the intent behind a competitor's change are often more powerful. You can't just look at the dictionary definition of alkaline earth metal. You have to look at the chemistry lab and the prior art to determine if a change is truly inventive or just a clever dodge to steal someone else's idea.
Right. The Graver Tank decision ultimately forces every inventor and every competitor to move beyond the literal text and consider what is functionally equivalent. It confirmed that the courts will not let patent protection be converted into that hollow and useless thing. It remains the defining test for when clever engineering becomes illegal copying, placing the line firmly in the functional heart of the invention.
Thank you for sharing these sources for this deep dive into the fascinating world of patent equity and the rules of the technological road.
Until next time.